Okay, we are on the last learning unit, which is learning unit 4. So remember to download your manual at the end of this training. Then you can always go through it at your own time, at your own leisure. Should you need to remind yourself of anything that we covered during this course, then you can just refer to your manual. Okay, now we are at the arbitration hearing. So the fourth learning unit deals with the arbitration hearing itself at the CCMA. So the arbitration hearing, it is where the parties get the opportunity to present their cases. An independent and an impartial commissioner or commissioners are appointed to adjudicate disputes. Arbitration hearings are new hearings, so the outcome of a disciplinary proceeding conducted in the workplace will not necessarily impact the mind of the commissioner at the arbitration. Okay, let me just read that again. So arbitration hearings are new hearings so that the outcome of a disciplinary inquiry that was conducted at the workplace will not necessarily impact the mind of a commissioner. So it's a fresh start, a clean slate. Okay, and then characteristics of an arbitration hearing. They're conducted by a neutral third party, which is the commissioner. The arbitration process is hearing the version of events of both parties, meaning the commissioner will hear the version of events from the employer and from the employee. Once the stage has been completed, the arbitrator issues an award with the reasons. So firstly, there will be the introductory stage when it comes to arbitration hearings. So at this stage, the arbitrator will introduce herself to the parties and will check if an interpreter is needed. Should an interpreter be needed, then an interpreter will be provided by the CCMA. So the arbitrator should also explain the process of arbitration to the parties and indicate that the proceedings will be recorded. So the arbitrator will give both parties an overview of how the process is going to go, and then you'll also inform them that the proceedings will be recorded. And then the arbitrator will also address any preliminary issues, such as an application for condonation, if it's applicable, an application for recusal of the arbitrator, and applications for legal representation, etc. And then the next thing that the arbitrator will do is what we call narrowing of issues. So before any evidence is led, the arbitrator and the parties should know exactly what issues are in dispute. So it doesn't help that we think we are arguing, or we think we are on different sides of the fence, only to find that we agree on certain matters. So that is where narrowing of issues comes in. So at this stage, the arbitrator or the commissioner will ask questions to ensure that he or she understands the issues that are in dispute. This is where the arbitrator unpacks issues with the parties before she starts hearing the evidence. Okay, then when it comes to presenting evidence at arbitration, so the main purpose of presenting evidence at arbitration is to give parties an opportunity to state their case. Representatives should avoid leading questions whenever they're doing cross-examination. And then leading questions are those questions that require a yes or a no answer. So irrelevant questions should also be avoided. So you ask questions that are relevant to the case and without actually leading your witness. As mentioned, that an example of a leading question is a question that requires a yes or a no. So for example, when you ask questions, you must ask open-ended questions. So an example would be, tell us what happened on the 2nd of March, 2023 at the beginning of the shift. And then the person would start explaining, say maybe the particular incident that you guys are sitting with concerns an event or an incident that happened at the start of the shift on the 2nd of March. Okay, here are more examples of open-ended question. When you spoke to Beyonce, how did she respond at the beginning of the shift? And then maybe the witness will say Beyonce was rude, she was aggressive, she started pulling up her sleeves as if she was getting ready to fight. And then cross-examination. So cross-examination, this is a more vigorous, robust approach to questioning. Questions are put to entice the other party to agree to certain facts that may support the version of events of the other representative. The representative will aim to also show any contradictions or things that seem irregular or improbable in the other party's testimony. So cross-examiners should not be rude or aggressive. So here are a list of questions or examples that you may ask during examination, cross-examination rather. Are you saying that both the clockings report and the hours of the pay slips are incorrect? Where were you that night? And then re-examination. This is an opportunity for damage control. So let's say maybe you bring your witness and then you would ask your witness open-ended questions, and then the other party will cross-examine your witness. And then in order to do damage control, you would do what is called re-examination. So remember, the purpose of cross-examination by the other party is to poke holes in your evidence and to poke holes in your witness's statement. So now here you try to do damage control where you do what we call re-examination, okay? And then here's a checklist of questions in examination, cross-examination, and re-examination. So let me just make this bigger. Okay. Okay, my screen is a bit disturbing me. Let's see if I can move it up. Okay, I can move it around. So the purpose of this is to give the witness an opportunity to state what happened. And has the witness stated and explained what happened? So this is a checklist that you can actually print, and then you can take it with whenever you go to the CCMA. But as you get used to it or used to representing cases at the CCMA, then maybe you might have less and less need of this. But I always like to keep checklists. Even when conducting disciplinary inquiries, I'm one that likes to conduct, or rather to keep checklists. And then you must ask yourself, am I asking myself open-ended questions? Questions like, can you tell us, why do you say? And then has the witness told the arbitrator everything that is important? So this is examination. And then cross-examination. The purpose of this is to test the evidence of the other party and to show any contradictions or improbabilities. As I said, that you want to poke holes at the evidence presented by the other party's witness, or the other party tries to poke holes in the evidence presented by your witness. Okay, and then just make sure that you're asking the right questions as well. And then make sure that you ask all the questions that you'd like to ask. So preparation is key. As they say that if you don't prepare, you will repair. So prepare questions in advance that you want to ask. Make notes of questions that come up that you would like to ask as well. And then re-examination, remember the purpose of this is for damage control. So questions that you need clarity on, and anything else that you might need to do damage control on. Okay, just want to escape this screen. Not sure why it's not escaping. There we go. Okay, and then the next one is closing arguments. So closing arguments may be heard verbally or in writing. The arbitrator, at the request and with the consent of all parties, may allow parties a maximum of a week to submit closing arguments in writing, but it's also important for you to prepare them in advance as you go to the CCMA. So always make sure that you have all your documents, all your preparation in place. And then, so here it is where the parties get an opportunity to argue why the arbitrator should prefer their version of events versus the other party's version of events. So here it's a summary of evidence that was presented during the during the arbitration hearing, and together with case law and the interpretation of facts. Okay, and then just remember, a good closing argument should contain the following. What were the issues to be determined? So say, for example, it was a case of unfair dismissal that had to be determined. Maybe the worker was dismissed without a hearing, okay? And then why is the version more probable than the other? Maybe here you just show an email saying that here I was dismissing, don't come back to work, we don't have money to pay you. So clearly there was no hearing that was conducted, the procedure was not followed. What other legal principles do they rely on? So referring back to the example where I stated where somebody, Mr. Trouble Ndlovu, was dismissed without a disciplinary inquiry. So the legal principle is that the worker should be afforded an opportunity to present their case and to present witnesses and to cross-question the company's witnesses as well. And then what facts do they rely on, why these facts should be accepted and the facts and the other facts not be accepted. And then you refer to case law where appropriate, and then you say the relief sought. So the relief sought, you would say, I require that Mr. Trouble Ndlovu be reinstated and maybe a proper disciplinary inquiry be conducted. So now the next activity is activity 7 in your manual. I will also upload a one-pager PDF so that you can do it. So here it's basically a similar activity to the one that you did at the beginning of the course. So it's to assess if you've learned or gained anything new, and then you can compare your answers that you are answering for activity 7 with the ones that you answered for activity 1. Thank you. I do hope that you have enjoyed this course. So these are our contact details should you require more information on our courses that we offer related to human resources management, anything HR, IR related, IR meaning industrial relations. So these are our contact details, 061-509-7806 South African number, telephone number also South African number, 081-722-3775, or you can email me at kumzile.msiza@musahr.co.za, or visit our website, and we are available on socials at Musa HR. Bye, and I do hope that you have enjoyed this case, or rather this training.